this video, I will give you a short introduction to the sources of international economic law. I will begin with an overview of sources of international law and highlight some aspects of particular importance in international economic law. We will then turn to the principles and the standards of international economic law and conclude with a short reference to the spaces of self-regulation by economic actors. These play a major role in shaping business transactions and cannot be ignored by practitioners of international economic law. So let's start with an overview. The traditional starting point to approach the sources of international law is Article 38 of the Statute of the International Court of Justice. As you can see in this slide, I've highlighted the main sources of international law: international conventions, i.e. treaties and agreements, international custom, and general principles of law, with judicial decisions and the opinions of the most highly qualified publicists of various nations as subsidiary means to determine the rules of law. This taxonomy is, however, incomplete. It was drafted at the end of World War II to structure the sources of law for the purposes of the decision of cases under the jurisdiction of the World Court, as can be seen by the reference to equity in paragraph 2. In the next slide, I try to sum up the sources of law that are most relevant to international economic law. So first you have the traditional primary sources: treaties, custom, general principles of law, and the unilateral acts of states and international organizations. Then you have subsidiary sources such as judicial opinions and so-called rules of courtesy between nations or comity. I left out the writings of publicists. Instead, please note the relevance of judicial decisions that we will cover in part of our course. These include a few rulings by the International Court of Justice, arbitral decisions by tribunals set up under the ICSID Convention to judge investor-state disputes, and the reports of WTO panels and its appellate body. One characteristic of international economic law, by no means exclusive to it, is the role played by soft law. A division is normally drawn between, on one hand, so-called hard law, in the sense of binding rules of international law, the breach of which gives rise to state liability, and, on the other hand, soft law, that is to say, in broad terms, rules of uncertain legal force. This uncertainty may be due to the content of such rules, for example, rules that express desirable goals or intentions without prescribing specific conduct, or because, regardless of the use of more imperative terms, they are integrated in non-binding sources. We will see that UN General Assembly resolutions are particularly important in certain domains of international economic law, although they are non-binding recommendations under the UN Charter. So, if soft law is not binding, does it matter? Well, we can ascribe two main functions to soft law rules. First, soft law provides guidance that is important in developing future rules of law. Secondly, by creating a reference of desirable behavior, they bring about predictability, insofar as states actually comply with them despite not being binding. This is very relevant in areas where states are not ready to assume binding commitments, but make a soft commitment to a certain type of conduct. Moving on to the principles of international economic law, these were drawn by Professor Georg Schwarzenberger from traditional principles of international law, mostly dealing with freedom of movement of trade on land, sea, and air. These we tend to take for granted until a disruption of international order occurs. Freedom of commerce deserves a special reference here. The predecessor of the International Court of Justice, the Permanent Court of International Justice, defined this principle in the Oscar Shin judgment of 1934 as follows: freedom of commerce is the right in principle unrestricted to engage in any commercial activity, whether it be concerned with trading properly so called, that is, the purchase and sale of goods, or whether it is carried on inside the country or by the exchange of imports and exports with other countries. This raises a few questions that in a globalized world we tend to ignore. Can we say that freedom of trade is a customary rule and that any nation that closes its markets and prevents trade between domestic and foreign economic agents would be in breach of this principle? As you can see in this slide, it is long and well established that this principle relies on its enshrinement in treaties to be effective. As the 20th century German scholar Wilhelm Röpke argued, Its basis is the principle pacta sunt servanda. In other words, the legal nature of the freedom of commerce is a treaty-based rule or a unilateral act of a given state. There is no such thing as a right to commerce with any given state outside this voluntary framework. Let's now shift our attention to the standards of international economic law, as these also play a key role in different areas covered by our course. A bit like jazz standards, where you recognize the melody of a well-known tune that is then played in the typical improvised style of jazz, these standards are anchored on the expectations that they create in economic agents. For states, they also make the rules more manageable, as reference to these standards replaces what would otherwise be very complicated treaty provisions, attempting to cover all possible situations emerging from the implementation of the treaty. So, instead of starting from scratch when negotiating an economic agreement, states tend to opt for including these standards. One important thing to keep in mind is that these standards will always require a comparison with other rules. These can be domestic rules or rules in other international instruments that do not bind all the parties in the agreement using such standards. So let's for now consider the most important standards that we will study later in the course. One of the most controversial is the minimum standard for the treatment of foreigners and their property. Being a minimum standard, this entails that there is a right to a minimum type of treatment regardless of other applicable rules. Then we have the standard of reciprocity. A will have the right to the treatment from B that is symmetrical to what it gives to B. Preferential treatment means that the parties will be entitled to better terms than those accorded to other parties. The degree of preference will have to be detailed in the agreement. Finally, we have two standards that are in fact two sides of a general non-discrimination principle: the most favored nation treatment, or MFN, and national treatment. We will deal with these extensively in other parts of our course. For now, keep in mind that MFN entails giving the other party the best treatment accorded to any other nation. In other words, this is an assurance of equality in any preferential treatment granted to other nations. National treatment, on the other hand, aims at preventing a discrimination between the treatment afforded to nationals or goods or services of one party and the treatment granted by the importing country to its own economic agents. In other words, it aims at ensuring equality of conditions of competition between domestic and foreign economic actors. Coming now to the last topic of this video, we have a reality that is not a source of international economic law, but is part and parcel of everyday international trade. If you have already had a course on commercial law, you will certainly have heard of the lex mercatoria, or law merchant. This refers to the emergence of a private law order co-opted by European merchants in the late Middle Ages and early Renaissance to facilitate trade and finance between different nations. Its modern version includes the self-organization of financial markets and the definition of standard clauses that are independent of domestic rules and well known to economic agents operating in international trade. This private law order even goes one step forward by creating its own court system, by resorting to private international arbitration. Ultimately, there will only be a need for the parties to refer to state law where there is a need to enforce an arbitral award before a domestic court. I leave you with this slide where you will find some of the most common Incoterms, or international commercial terms, managed by the International Chamber of Commerce. Please visit its website for more information on these topics. So, I hope you enjoyed this video, and I'll see you in class.